Good evening, everyone, and welcome. We will start here in just a moment. Welcome to EXIT Strategy Realty's Consumer Education Series. We're excited to have you tonight. We've done some of these in person. We did our June event in person. Obviously tonight, August thunderstorm outside. If for some reason we do, if I lose power, stay on the Zoom. It is being recorded. If you lose power, it's being recorded. If for some reason we all get kicked off, we'll log right back on. I do have my phone with me. I was just on Instagram with Instagram Live watching Larry Mowry, a friend of mine, longtime friend, and a client of mine who's the chief meteorologist at ABC 7. He says, at least on the north side of the city, we've got this for about another half hour. So, but I think we'll get through the storm and we will certainly get you some great content. So what are we here to do tonight? Well, at EXIT Strategy, we focus on 4 key focus areas. We call them our 4 pillars when we do our consumer education. The first is real estate. Obviously, we're here to help you buy, sell, and invest in real estate. But then also we focus on health and wellness, personal finance, and charity community events. Tonight, we are focusing in real estate, but it's also about your personal finance, because whether you are a current owner of a condo, whether you're thinking of buying one, or maybe for yourself or for a family member or as an investment, there's some significant things you want to think about when you purchase and once you own as an owner. And I myself am president of my condo board. I've been on my condo board for 9 years. We've got some friends of mine. Actually, one of my friends, Rob, is on tonight, who is on his condo board at a much bigger building than mine. My friend Brent might be joining us as well. He's secretary of his condo association, a large condo board. So you get all mixed shapes and sizes of condos. The vital thing you want to know is that you, as part of a condo community, you own a percentage ownership or a percentage of the building entirely. So you're responsible, along with all the other owners, for all the health and fitness of the building. You can't just sit back and think it's all going to be taken care of for you. It is, but you need to be active in terms of, on the way in, doing your due diligence. And as you're an owner, everything that happens in that condo building does affect not only your current day lifestyle, but your future investment, your appreciation, and your resale value. So it's a very important things to consider, which is why I'm bringing on a friend of mine tonight, another longtime friend of mine, my friend Matt O'Malley. He is an attorney specializing in condo associations. It's a rare type of legal specialization. You find, there's real estate attorneys and they're great, but an attorney that focuses in the condominium association genre, it's they're a rare bird. So we appreciate Matt's time tonight. He is with Tressler LLP here in Chicagoland, so he's going to be a huge resource for us. Before we do dive in, I do want to share my screen just for a moment. I want to give you one more resource before I turn it over to Matt. And what this is this is a blog that I have up that will hopefully be helpful to all of you. It's on my LinkedIn. It is a not only written blog, but it's also a video with some of my experiences over the past 23 years being a condo focused broker. I do all types of transactions, as do most of us at EXIT, but I seem to be in a lot of condo buildings. Just that's the nature of the beast of living in the city. So I wrote a piece, and this is a while ago since I wrote this, so I think it's almost due for some amendments, but I've got kind of a top 10 list, 10 key things to be looking for on the way in. My guess is Matt will have his own list for you tonight, but I talk about reserves, deferred maintenance, percentage of owner occupancy, rental caps, all that good stuff. If you, for some reason, don't like, kind of reading blogs as much as you like just watching a video, I do have an entire video up there as well. So that's on my LinkedIn. Feel free to check that out later, but I bet you that you're going to learn a lot more from Matt than you would from me tonight. So I'm going to go ahead and turn the presenter role over to Matt O'Malley. Again, longtime friend of mine. I remember when Matt was, I think, just in law school when we first met. And since then, we obviously have been, doing our own thing and watching him over the years grow his practice and ending up specializing in condo associations has been fun for me to watch. And now hopefully a great resource for all of us on our consumer education series. So Matt, I'm going to make you the presenter. Thank you for letting me be a little bit long-winded there in my intro.
Sure. Thank you for the introduction, and thank you everyone for joining this evening. I know it is a stormy night, and I appreciate you spending some time with me and with Nick. As Nick said, I am an attorney. I am a litigator by trade, but I serve as general corporate counsel for numerous boards of directors on several Chicagoland condominiums and townhomes and other community associations. So tonight's webinar is really going to be geared to helping you all better understand some issues related to life in condominium associations. I'm planning on sharing some practical considerations regarding purchasing a condo, and then after you get the keys, life as an owner, some of those frequently asked questions that come up, providing insight into some legal issues that I've encountered in my 7+ years practicing in this realm. And really just trying to be informative. And since we have an intimate crowd, I'd be happy to field some questions later on as well. One caveat to that is please do not share personal information on this. This is a public forum, and so want to make sure that we are, keeping things confidential. But if you have general questions, I'll be happy to answer them later on in this webinar. So I think we all know there are certainly many pros to living in a condominium association. Oftentimes, especially in the city of Chicago, they are one of the most affordable options to own a piece of property in the city or another urban environment. And condos provide a great sense of community. They allow for individuals to focus on maintaining their unit. But as Nick said, there are some really important considerations before you purchase a condo. And then once you are a condo unit owner going forward, just life there and things like that. So it is a considerable investment, but that investment is long-term. You're going to have assessments, you're going to have maintenance, you're going to have special assessments. So there's definitely a considerable investment, not just initially, but throughout the course of your time in your condo. So I'm going to drop my information in the chat so that you have it, because as I said, my little caveat before we really get into the heart of some of these issues, I don't want you to share personal information on this forum, but if you do have a question and you'd like to follow up with me, I'd be happy to provide confidential pro bono complimentary consultation afterwards. So some of the frequently asked questions that I have, and a lot of the times, people might know some of these answers. So by all means, if someone wants to chime in, or share some of their perspective, please do. I want to try and make this as interactive as possible. So if you want to drop an answer into the chat, by all means, please take part in this. I'm trying to make this as interactive given the pandemic that's ongoing and the fact that we can't meet in person. So what exactly is a condo association? If anyone has an idea, or if you want to shoot some one-word descriptions of how you feel about condo associations, I'm happy to kind of field some of that and explain.
I guess I'll start off a little bit. It's kind of like the same thing as when you have a subdivision. Everybody owns their own individual piece of land, or in this case, there are 4 walls, the interior, there are 4 walls, but you are all operating as a community, hopefully for the better good. That's my very brief thought of it.
Definitely. And I think, a lot of people see the physical components of a condo and a condo association, so the building, the amenities that are provided, but they don't really fully understand or comprehend what's going on behind the scenes. So there's a lot involved in a condo association. As Nick said, it's really owning a part of the common elements. And it's not just the physical building. There is accounts receivable, accounts payable. There are contract issues that are going on in an association. There's really a lot going on. And so I really want people to kind of be mindful of that, because we're going to get into more about how to be financially sound and being a smart consumer when you are purchasing a condo, but also living in a condo. So condominiums, they have governing documents. And some examples of governing documents include a declaration, bylaws, rules and regulations, any amendments to governing documents. I see all the time, the developer will create a declaration back in the 70s when the building went up, and it's out of date after a few years. Yet, condo associations are still utilizing the original declaration. So declarations are living, breathing documents. They need to change with the times. And that really is it's really the operating agreement of the condo association. They're usually a 30+ page document. There's a lot of legalese. They can be very complicated, but I think it's important to review the table of contents. The table of contents is going to have all the categories or all the articles broken down in a somewhat easy way to understand, so that you can see your unit owner obligations, board obligations, insurance provisions, you name it. The table of contents is a good place to start. I think another really important page in your declaration, or pages in your declaration, for the layman who doesn't have a legal background, is looking at the definitions and understanding what is categorized as what. As I said, the declaration is going to have several articles, and it's going to discuss many different things: how boards are elected, leasing issues, a lot of different things are on there. Any restrictive covenants. Sometimes we have some communities that are senior communities, so they're 55+ age. So you really, really want to look at that document, because it's going to tell you some critical information as to what you're buying in, how your condo association is run, and really how it's governed. So some of the laws that govern condos in Chicago are the Illinois Condo Property Act, and I will be referring to it a couple times in this webinar. I refer to it as just the Condo Act. So when I say the Condo Act, that's what I'm referring to. There are Chicago municipal codes, and there are Cook County municipal codes. And these are, for lack of a better word, building codes. So whenever there is a issue, something as easy as not removing snow on an egress outside of the building, to something as complicated as a huge capital improvement project, those municipal codes are going to govern those issues. And last year, because of the COVID pandemic, there wasn't much inspections. The city of Chicago and Cook County have inspectors that go out and look at buildings and make sure that they are in compliance with the municipal code. And they will cite you for something as small as not having a proper management sign, to something as large as a balcony deteriorating, which would be a life safety issue. We got a pass last year. This year was kind of a mix. Given what has happened in Surfside, which was that tragic incident in Florida where condominium collapsed, the enforcement issue is really at the forefront of a lot of municipalities right now. So I suspect that inspectors will be out in full force in the coming months. I know we're going to have a long Chicago winter, but it's really no reason to not be mindful of that. As far as those kind of broader laws, there's also the Illinois Forcible Entry and Detainer Act, which is when, hopefully this isn't a situation that arises in your association, but if someone needs to be evicted, that's the act that governs. And then there's the internal structure of your association. So there's going to be rules and regulations and a declaration, which we kind of discussed a little bit. That is going to lay the groundwork for what happens inside those walls of your building. So some common legal issues that I think condo boards face that I see a lot are, like I said, those building code violations, collections sometimes against unit owners for unpaid assessments, enforcement actions against unit owners to remedy a breach. I have general corporate work, so just assisting condo associations and condo boards in their day-to-day affairs. Sometimes we have litigation with unit owners, and the board has involvement in that, whether it's disputes between them, disputes between vendors, contract review, there's education, and then elections, voting, and board meetings. So your condo association, as I said earlier, it's not just a pretty building or amenities. There's really a lot going on. It's a non-for-profit that is governed by volunteers. So it's really, really important that these volunteer board members, which is a thankless job, but it's an important job. And I think there are resources out there to assist boards to effectively manage their associations. So an association is formed in Cook County after a building is constructed, and it's really the declaration and an articles of incorporation that starts that process. It's recorded with the Cook County Recorder of Deeds. A non-for-profit corporation is registered with the Illinois Secretary of State, and association is formed. I did reference some common elements, and I want to explain that in case anyone is unfamiliar with that term. But those are portions of the condo that don't include the units. Examples of this are pools, gym facilities, roofs, internal pipes, HVAC, laundry rooms, hallways, lobbies, elevators. So if it's not in the four corners of your unit, it's likely to be a common element. There are some limited common elements as well. Those could be balconies, patios, parking spaces, and those really, each declaration is going to have knowledge as to the duty of a limited common element, but oftentimes what happens is a unit owner only has access to a limited common element, such as a balcony. And so the board characterizes it as a limited common element because it provides them the authority to address maintenance, but at the charge of the unit owner. We have assessments to pay for these common elements. Assessments are effectively your monthly charges. You have special assessments, which are usually larger, think 3, 4, 5, maybe 10 times your monthly assessment. And that's usually in the case of an emergency when there isn't proper reserves. I talked a little about Surfside, and Surfside really provides a case study for really how not to govern an association, but also to be aware of some things to look for. And one of the effective tools that boards can use when evaluating their financial health is what we call a reserve study. And a reserve study is this tool that really assesses the finances of the association. It's really a very thorough investigation as to the association's liabilities, costs, any projects that are needed, any maintenance. And usually what happens is an engineering firm will come in and they will look through everything, they'll review everything, and they'll provide a recommendation as to what it's going to cost. And so after that reserve study is completed, the board has this information, they have this knowledge, which is critical to make decisions. They can look at the assessment and look at what these forecasted costs are going to be, and they can budget. So they can either raise assessments over a long period of time, or if it's a less urgent thing or something, for example, a roof that's going to deteriorate in 5 to 7 years, that's a cost that they can kind of forecast and prepare for. Sometimes though, a special assessment is needed because a pipe burst in the winter, or there's just an urgent need. So that's a real critical tool that I don't think, at least I certainly encounter. I encounter a lot of boards not knowing or understanding what that is or where to start on that process. And that's where I kind of help them navigate whether that's a need. So now that we have some basic terms covered, I do want to talk about condo association health. And that's really the premise of this webinar, it being a consumer webinar. So a healthy condo is going to be one that is financially sound. Proper accounting, budgeting, evaluation of risk, engaged membership are some of the other factors to ensure that your association's healthy. And as corny as it is, I like to call this my 4 M's. People will remember it. So the 4 M's that I have that I discussed really for a healthy association is money, mitigation, management, and membership. So I'm going to go through each one of those. So as I said, an association finances includes accounts payable and receivable like any other corporation. And since an association is a not-for-profit, it still has regular recurring expenses. There's still lights that need to be paid for to keep, there's bills that come in. Perhaps you have on-site maintenance, a pool, all these things cost money. So
Matt,
yeah.
sorry to interrupt you. We do have a hand raised. Rob Thompson from the condo building on Marine Drive, Imperial Towers. If you guys are familiar, he's on the board there. He had a question. Rob, do you want to go ahead and unmute yourself? He's unmuted.
Sure. Hi, everyone, and thanks for the personal identified information there, Nick.
we can get your unit number.
Yeah. But hey, Matt, I had a question about going back a little bit to your mention on the hierarchy of governing documents. So we have the declaration, the bylaws, and then the rules. So my question is, where does local, state, and federal laws come into play here? For example, the recent citywide mask mandates, and does there need to be explicit rules in the governing documents that are otherwise covered in local and state mandates and laws?
Great question. So I think to provide some context, the Illinois Condo Property Act is going to govern. So if your declaration veers from that, that is an issue. Now, I know that's not your question, but I think it provides context to the rest of my answer here. So I know this is ever evolving. We've reverted back to masks out of necessity. Rules are easier to change. All it takes is a majority of a board to edit rules versus a declaration amendment, which usually necessitates at least a 2/3 majority. That's what the Illinois Condo Property Act outlines. Your declaration might have a higher threshold for editing a declaration. So in this case, I think a simple notice to unit owners regarding the situation in the CDC updated guidelines or the County of Cook updated guidelines, City of Chicago updated guidelines should suffice. However, if you want it to be as clear as possible and to be able to enforce a rule, you can pass a rule with a board member vote. Now, unfortunately, there are some politics regarding masks, so that might not be the best route either. But I'm trying to provide, I'm providing at least what my recommendation would be, which would be to post, to have postings in common areas, maybe an elevator lobby, and really ensure that people are doing that. It's the law, it governs, and that's kind of my answer. I hope that answered your question.
Yeah, so do boards have enforcement authority for laws such as mask mandates that are not otherwise covered in the rules document?
So let's just take your example. If you guys did not pass a rule and you wanted to fine someone pursuant to your violation process for violating an internal condominium rule, I think you're going to have an uphill battle enforcing a mask mandate based on the City of Chicago or Cook County because you haven't internally passed that violation. And I'll be frank with you, this is novel, but that is my recommendation. I haven't encountered case law or an issue that states otherwise because it's so novel and it's so evolving. But I think you will have a difficult time having, if someone wanted to litigate you all enforcing a mask mandate if it's not internal to your association. Does that make sense?
Yeah, I guess it's just there's so many laws and local laws, state laws, federal laws, and governing documents can't identify all of them. So it's it's hard to say that you want to enforce it when you don't have them all identified. But I'm not sure if you need to.
So here's a good catch-all is your declaration likely has a noxious and offensive component to behavior and having to remedy that. And that's really a catch-all for a lot of different things. If your rules have a catch-all provision that states that unit owners need to be compliant with state laws and encompass what's going on here, I think that would be a good way to ensure that this is being addressed. Does that make sense?
Yeah, thank you. I appreciate the feedback. I don't know how to lower my hand right now, so
Don't
it's
worry.
still up.
Your hand went down on its own. So
I
Okay.
took your hand down, Rob. Thank you very much for that great question.
Nick handled.
Okay, thank you.
No problem. So I was discussing kind of the 4 M's, which was money, management, membership, and mitigation. And money, we all know, financial, accounts receivable, payable. We want to make sure that more money is coming in than not. And before you purchase a condo association, you really have an opportunity to review documents, and should. It's one thing to get them through a 22.1 disclosure, which is a Illinois Condo Property Act provision that mandates certain things be provided. But once you're provided them, you need to review them. I think so many people have these documents and they sit in a drawer and they collect dust. You really need to review them and be mindful of them and understand them. And if you don't understand them, ask an attorney for help. Sometimes attorneys will, help you, assist you on something complimentary. It doesn't always have to cost an arm and a leg to do some proper due diligence as a consumer. So as I kind of keep bringing up, Surfside is really a really good case study. And I think one of the big learning lessons from them that encompasses one of my M's is mitigation. And that was really a situation where the association knew of risks, but they chose not to, frankly, they ignored them. There was ample evidence from engineers that supported that there needed to be significant capital improvements. Areas of the association were not properly waterproofed. And this is South Florida. There's humidity, there's water, there's hurricanes. And so that led to the deterioration of this building. While that's an extreme example, it really does highlight the importance of making sure that we are addressing issues that need to be done and not kicking the can down the road. I referenced the Condo Act, and like I said, that serves as a foundation for many of these issues. But the Condo Act is really, really important in terms of showing what boards need to do and how they should run. So one of the things that I talked about are reserve accounts, and Illinois is actually, for as much legislation as we have, they don't mandate reserve accounts in Illinois. And so Illinois, I think that's going to change. I really do. I think given what has happened in Florida it's in front of everyone. It's really highlighted how things can be mismanaged. And it was tragic. So many people lost their lives. So I will suspect that if I had money to bet, I will suspect the legislature is going to further clarify and potentially mandate some more reserve language in the law. But as it stands, Section 9C2 of the Condo Act only requires that condo boards have reasonable reserve accounts. They don't provide, reasonable is like a wonderful legal word that is never defined. And in this case, it's not really defined. The legislature just provides some factors for a board to determine what is reasonable in their reserves. And some of those factors are repair and replacement costs of the estimated useful life of the property, the current and anticipated return on investment of association funds, an independent reserve study if they have one, and the financial impact on unit owners of the assessment increase to fund the reserves. So all of those factors are helpful in addition to the reserve study that I discussed to help set reasonable reserves. But Illinois only says it has to be reasonable. I think a lot of times there's a common misconception among some of my clients that people think, oh, it needs to be 10% of the budget. That's not the case. I think each association is different, but saving money and having that in the reserves is important because it helps forecast for emergencies or for major capital projects. So the next topic that I wanted to kind of address was really proper due diligence as a consumer or purchaser into a condo. And so, as I discussed, building finances are really important. And when you think of purchasing a home, due diligence is a really critical part. And I think when a lot of people think of a home purchase, it's a radon inspection. There's lead paint disclosures. You have a home inspection, and then there's usually a back and forth between the buyer and seller's attorney to negotiate the deal. When it comes to a condo, there is much more. Illinois law triggers what we call a Section 22.1 disclosure. And I know I referenced that, but I want to bring some more context into that because it's a really important tool, and it's an obligation on a seller to provide it to a buyer of a condo. So again, this is the Illinois Condo Property Act, Section 22.1. And in it says that a seller must disclose the declaration, bylaws, and other condominium rules and regulations, the name and mailing address of the association's principal agent, any liens, unpaid assessments, or other charges due on the unit, the unit owner association's projected budget and capital expenditures for the next 2 fiscal years, any funds reserved or earmarked for reserves, any lawsuits or legal cases that the association is involved in, information on insurance coverage provided for owners, and a statement of any improvements or alterations made to the unit. I know that's a lot to digest, but ultimately what these categories of information break down to is information for you to make an informed decision. It includes projects, maintenance projects, both to the unit and to the common areas, because at the end of the day, you're responsible as a condo owner for the common areas. It includes the financial health of the association in terms of what insurance that they have, what funds are in reserves or earmarked reserve, if there's pending litigation, which can say a lot about an association. If there's a lawsuit pending for a building code violation, odds are it's because something was neglected. So not only are they defending a lawsuit, and that's expensive, against the city of Chicago or Cook County, but there's also going to be the remedy, whatever the city of Chicago or county of Cook are prosecuting. For example, the roof needs replaced. There's going to be a cost associated with that. So that lawsuit or legal case that they're involved in is it's an important piece of information that I think is often overlooked. A lot of times you're not going to be able to get too much information out of a lawsuit because it's pending litigation, but you can do some research, especially a good attorney, to determine what the situation is, despite potentially the suit being under seal. I see another question, Rob. I will get to that at the end. And if anyone else has questions, you can drop them in the chat. As far as 22.1 disclosures, like I said, those are really important, and they need to be reviewed. So, excuse me, the 22.1 disclosure is important because that's your opportunity as a prospective new condo owner to kind of get an inside peek of what your association is going to look like. It's going to provide a history of condo associations' fee increases. And so a smart prospective buyer is going to want to know that information, read that information, and evaluate it before making a purchase. So I want to turn now to another component to this seminar, which is once you are in the condo. And I know I've kind of been jumping around a little bit, but I want to make sure we're covering existing owners, board members, and prospective buyers in this seminar. So one of my biggest pieces of advice as a unit owner and a board member is to really know your governing documents. Governing documents, like I said, is this operating agreement, and there is a lot of information in them. They're going to include conditions or covenants that dictate things like how large pets can be, who's covering landscaping, if you can rent, there's architectural control committees sometimes in associations. So whether or not you can put in a certain glass window, move in and move out fees. There's so many different things that are covered in your governing documents. And so that is really, really important to be a mindful consumer to review those. And then also as a unit owner or board member to really understand them, because that's how your association operates. The governing documents are going to include information about assessments, maintenance obligations, how a building is funding its reserves, any changes to amenities, whether there's going to be special assessments, board meeting minutes, types of insurance, you name it. There's so much information in those, and it's really, really important to review them. So if you are serving on a board, I have some advice, and this really goes for people and unit owners as well, people who are living as unit owners as well. First and foremost here, these are just some tips that I've encountered as a litigator, which is usually when things have already gone awry, a litigator kind of comes in and handles and tries to clean things up. So first and foremost, I would say be reasonable and proactive. If you're serving on a board or you're a unit owner, always try to work things out before anything escalates. Condos and HOAs are communities, and the person that you're in a dispute with oftentimes is a neighbor, and you're going to have to live with each other. There's going to be an existing relationship. So really try to be reasonable. Try to, at the end of the day, follow your rules and regulations, and really try to work through a resolution on an amicable basis. It will save a ton of money if I don't have to be involved. And while that might be beneficial to me, my goal is for my clients to not have to litigate. So if we can be proactive and sort through problems and anticipate problems before they happen, that is a win-win. It will save clients money, but it also helps preserve the community and the people and keep everyone financially sound and happy with their investments. Secondly, I think, this whole seminar has really been making informed decisions and really understanding your obligations as a unit owner, but also if you're a board member or you choose to be a board member at some point in time, understanding that obligation as well. That declaration is really going to help you understand and get a better sense for your duties as a board member and as a unit owner. I think failure to comply with governing documents is single-handedly one of the biggest issues that I find myself in court for. So making sure that you're utilizing your legal counsel when issues get precarious, or there's some nuances in the situation is really important. Oftentimes, associations also engage in property management, and I think that's an area too that can help boards kind of navigate through issues before they really escalate to a legal issue. I've talked a lot about the declaration. I want to talk a little bit about rules and regulations. I know it was a topic that has been brought up in a question. Your rules and regulation is going to include a violation process, a violation hearing process. So knowing those rules are going to help a unit owner avoid breaking them, and knowing the violation process will assist a board member or unit owner ultimately comply and have the board function effectively in enforcing the governing documents. One of the most important pieces of advice that I tell my clients time and time again when it comes to their declaration and enforcement of rules or enforcement of some remedy to a breach of the declaration or the rules, you have to objectively apply your governing documents. Subjective application or kind of nitpicking what you're choosing or who you're choosing to prosecute cases against is going to lead to trouble. Not only that, it is exhibit A to a discrimination case. So make sure that you are applying your rules to everyone in an objective fashion. I think sometimes board members don't want to be the bad guy. They don't want to enforce rules. Maybe the culture of the association was self-managed for a while, and it's just kind of a laissez-faire vibe. I don't recommend that. It's just going to lead to a bigger problem. It's really something, objective enforcement of the governing documents is going to keep your community operating soundly. It's going to avoid legal heartache, financial, issues. It's really, really, really pivotal to a successful association. As to a violation hearing process, here are some pointers on how that proceeds, and this might be more for our board members' knowledge, but I think these are some key pointers that I want to share, because this is one of the big parts of operating an association, is making sure that things run smoothly. And this is the absent litigation. This is the board's first opportunity to rectify a breach. So as a board, when you're running and prosecuting a violation, you want to make sure that you have a good timeline of the rule violation and the enforcement actions. So if you're sending out a warning letter, make sure you keep proper records of that. If the warning letter is not heeded and you want to issue a fine or another warning, make sure that's done properly. Look at your violation process. A lot of these violation processes are similar, but there are certain nuances. There are certain fine schedules. There are certain violations that may be egregious and flagrant, and so you can jump from a warning right to a fine. You want to understand that process. If the violation notification is answered by a unit owner, meaning the unit owner requests a hearing needs to be held. There was a case, the Boucher case, very pivotal case in Illinois, that really stressed the importance of unit owners and their due process rights. And although it's an internal condo violation hearing, we're not saving the world, a unit owner still is entitled to due process. And so it's really important that you are objectively applying this and you're following what your procedures are. If a unit owner requests a hearing, they need to be provided a hearing. If the unit owner requests evidence, so whatever evidence that the board has to support the violation, that needs to be provided. The Boucher case really came hard in favor of unit owners to ensure that these due process rights are held. So you want to make sure that this is being done. Each association is different, but this violation process usually starts with a letter. It's got to be sent to the unit owner of record. So if there's a tenant in there, you can't send it to the tenant. Technically, even if the tenant is the one engaging in the noxious and offensive behavior, the unit owner is who's being is who's actually liable for the fine and who is not in subject of the declaration or the rules or whatever the alleged violation is. So that notice needs to go to the unit owner. I recommend that the letter includes specific violations with dates, conduct, whatever damages there are. So if someone was drunk in a hallway and knocked down a fire sprinkler, include that information, include what those damages are. And then a citation of whatever the rule is or the declaration provision that's being broken. Also, you want to make sure you're including a deadline for compliance. So if it's something where they don't have a lease on file and they can rectify the breach within a time frame, make sure you have an explicit deadline for compliance for them to rectify. The letter should also include that there's going to be a warning and that they could potentially be liable for fines. They could potentially be liable for court costs. The Condo Act and declarations allow for associations to recover their attorney's fees if they are seeking a remedy of a breach by a unit owner. So that's a very, very, very favorable provision for boards of directors, because they are not, the association or the board is not responsible for legal fees in these situations. They can be asserted as a lien against the unit owner and basically added onto their ledger, which is significant leverage for getting compliance in these cases. But as a unit owner, On the opposite end, I know we've been focusing a little on boards right now. Unit owners need to be aware of that. When you come into a condo association and you are acting awry, or you're in violation, or you decided to put in navy shutters and your declaration allows only for black shutters, and the association hires a lawyer and decides to rectify a breach because you're being stubborn, you are on the line for those attorney's fees. So that is a huge issue that people need to be mindful of. And no matter what side of the coin you're on, if you're a board, it's obviously a pretty favorable provision. If you're a unit owner, it arguably could be unfavorable. But boards are volunteers. So the leverage that they have to ensure that associations are being run in accordance with Illinois law, their governing documents, it's needed. It's a thankless job. And I think I really have sincere appreciation for boards and people who decide to be on boards, because you're not paid and it's hard work. So not to scare anyone for not joining boards, I think they can be very rewarding. You can make a very meaningful impact in people's lives, in your community's lives, and address, you know, issues, but you got to be mindful of these things. So once you get the hearing, the letter's done, all that, the board will allow for the unit owner to present whatever evidence they have. And I always recommend that the board ask questions at this point in time if they have any. They close executive, they deliberate in an executive session, and then they make a determination. And the determination is, it doesn't have to be that evening after the violation hearing. The board can sleep on it. Usually most good decisions are not made in a rush. And then once they've made a decision, a determination letter is sent to the unit owner based on whatever evidence came to light. And if they're in violation, you know, any penalty is assessed. And then at the next board meeting, the board should vote on the determination and include it in the meeting minutes. I haven't talked about meeting minutes at all, but this kind of inspired me to. Board meeting minutes are critical. They can be accessed by unit owners. They should be accessed by unit owners. They're not necessarily part of a 22.1 disclosure. So that is something, if you're kind of coming into a condo and you want to get a flavor for what's going on and what has happened over the past year or two, request those meeting minutes. Proper meeting minutes are important as well, because that's going to be the historical record. So you want to make sure as a board you're taking proper meeting minutes. A board secretary usually has that honor to conduct that, to help assist with board meetings, but sometimes property management will do that as well. So I know we have some questions and I want to answer some at this point in time. Give me 1 second so I can go through. Okay. Okay, capital expenditures, Rob. What are capital expenditures? 22.1, you know, is very explicit regarding listing them. Is there a definition of what capital expenditures include? I've been unable to find the definition. So capital expenditures are, my advice on this is to be, if we know as a board that there is a project on the horizon and we have taken steps to engage vendors, that is 100% a capital expenditure. If we're in the investigatory phase and we don't quite know where we're at, you know, we want to balance that because we don't want to scare off prospective unit owners. So we shouldn't be disclosing, you know, oh, we're probably going to need a new roof in 20 years because that's the average roof life on a building such as ours. So we need to disclose that. So there's a balance here. If you know of something, it needs to be disclosed. If we're in an investigatory phase, like I said, and we've contacted a vendor and they've provided us quotes, but we haven't necessarily pulled the trigger and signed the contract, but we're going to, or it's contemplated, or it's very foreseeable in the next year, disclose it. the whole purpose, context behind these things, I think helps understand why I'm answering this way. The whole purpose of a 22.1 is to basically not give sticker shock to a prospective purchaser. So we want to make sure that this person comes in and is not going to be hit in the face with a $10,000 special assessment because the pool needs new tiling. If we know that that's an issue and we're forecasting it, we've discussed it in board meeting minutes, we've engaged vendors, that's where we need to disclose it. We might not necessarily have raised the financing or signed a contract, and there's a caveat there. You can put that it is, this is a potential one. It's not so hard and fast, if that makes any sense. Did that answer your question?
Yeah, thanks, Matt. Just for clarification, studies, does that count? For example, I know there's a lot of condo buildings across the city ordering structural assessments right now.
Yeah.
Those type of studies, does that fall under, requirements for disclosure on 22.1?
So it depends. It really depends on the result of the study. And so if you kind of recall my answer prior, if the study comes back and there's this urgent issue and we know we have to address it because the building's going to fall in, disclose it. So it's the fact that you've retained someone to investigate and there's a reserve study doesn't necessarily obligate a disclosure, because it might not amount to anything at this point in time. But usually when studies are done, we know something that's going on and we know we need to do something. And you don't want to be found culpable for withholding information that is known. And there's usually a record. So I always err on the side of caution. It is a case-by-case situation. There's not one answer suits all. But if you're questioning it, odds are it should be disclosed. Let's see, question as well for the end. Sorry, trying to go answer them in order. Nick, I'll get to yours at the end, as you said. Are there prohibitions on video recording as a form of meeting minutes? I would not recommend video recordings, and I'll tell you why. I referenced the Boucher case, and that Boucher case, check it out if you're bored. I'll happily send you a synopsis of it via email, a digestible version of it. But it really comes hard in favor of a unit owner who sued for essentially his due process rights. And the Illinois Supreme Court stated that video recordings count as meeting minutes. And video recordings cover everything. So you're getting facial expressions. You're getting anything that anyone's saying during this recording. And so you want to be sure that your meeting minutes are proper and they are in writing. There aren't any prohibitions. That's the answer of your question. I'm sorry, that's your question. But the answer is there's nothing prohibited to recording videos for your board hearings or for your board meetings. But I recommend strongly against it, because they can, and if they're asked for, they need to be disclosed. Make sense?
Yeah, thank you. It's definitely a hot topic today with the ease of recording, such as recording this webinar right now, as to the utility of that as a form of meeting minutes. So thank you.
Yeah, no, I think, and look, for a large portion of time, and really we're back at it for the most part, meetings are virtual. It's the only way we've been able to accomplish business these days. So thankfully for that, but I wouldn't record them for really that Boucher case. And I'm happy to provide you, like I said, a digestible version or circulated digestible version of that case. It's now, God, it's probably 6 or 7 years old now, maybe even longer. And it's one of the biggest, not too often the Illinois Supreme Court is hearing cases on condo life. And so when they do, and they have something to speak about, it really impacts a lot of what's going on in in condo associations. So I definitely would recommend strongly against recording your meetings.
We have a question from Carmen. Carmen Dennis, wonderful agent at EXIT. She's got her hand up. Carmen, you direct message me your question. Would you like to ask it yourself? There she is.
Hi,
Carmen.
Hi, Carmen.
I'm good. How are you? I
Good.
can do that. So if a unit goes under contract and for some reason you receive all the documents and you have the financials, and for some reason it does not close, but you have the financials, if other realtors are asking you about the financials and asking if they can see that, is that something that we can do or no?
So that might be better suited for Nick, because I don't know if there's I can't answer that question at this point in time. I don't know one way or the other if there is anything that prevents you from disclosing that information. I don't know. Now there could be something in terms of a realtor code of ethics that you all have to abide by. But as far as I know, my inclination is no, you shouldn't disclose that. But I don't know of anything. I haven't encountered that, and I'll be frank with you. I don't do a lot of. I don't do any transactional work in terms of real estate closings. So that might be, and I don't want to put Nick on the spot. I don't know if you know the answer to that or not, but I can get back to you on that for sure. But my inclination is no.
Okay, so I will.
Okay.
I'm happy to be on the spot for a second. I got my Zoom light on. I'm ready to go. So Carmen, are you? So in this scenario, would you be representing the seller or the buyer?
The seller. I represent the sellers, and usually when the deal dies and then people are coming and they're showing the unit, they always want to know about the financials and kind of like where they're at with that, and they always want to kind of see the numbers and how they're going to actually proceed. And I don't know if it's because these are investors more so who's asked for these, and not more so like actual buyers who's going to move into the unit.
Okay, well, I'm going to be pretty blunt on this. I sit there as a seller's agent and ask my sellers to give me as much information as possible up front so I can do my job. The bottom line is whether they're cash buyers, investors, owner occupants, they have the right to the condo documents from the condo association. Now, if you as the agent for the seller are told by your seller, hey, I handed you some documents, but those are not for public use or not for distribution, absolutely, you can't hand them out. But you can certainly defer to the condo association management, or that, if it's a small building, say, well, here's the president's contact information. You can put it right in the MLS and defer to them, because you can't withhold information to the point that the property would never close, because that's the whole point of condo documents, is so that the buyer has an educated decision point to make, which goes back to my question.
Yeah, I guess it would be when you're not in an executed contract. Usually they're asking for these to see if, I guess, as a decision-making tool, if it's something that they want to move forward with.
So Carmen, if I can jump in, I kind of have a better sense of the situation, and correct me if I'm wrong. If there is a transaction and one buyer fell through, but you've got another one lined up, absolutely, I agree with Nick wholeheartedly. Disclosure, that is a right pursuant to 22.1 for that information. But if you're sharing this information to another realtor just for intel or whatever it is, that's where I'm a little hesitant, because I don't necessarily know if I would err on the side of caution, because if you're producing information of a respective association to no one that's coming in and you're just kind of sharing it around, you want to make sure you're contacting that association. And like I said, this is all, I can look into this matter more, but that's just my inclination at this point.
Matt, you bring up a really good point, because I was going to go all the way to the left or right or whatever direction you want to say, and say that, well, if you have the information, I would put it out there so you're not wasting your seller's time or the buyer's time, either one. Because if you have if you've got a condo that maybe doesn't allow rentals, or has some things in the budget or minutes that might be concerning to a buyer, and you just don't put that out there because you don't want to scare off a buyer. Well, if the buyer goes under contract and sees that during attorney review, they're going to kill the deal and your seller has lost market time. But Matt, you brought up a good point, is make sure that the condo association is aware that you are disclosing those. You know, you can't just throw them out there without some sort of making sure that the association is okay with that. That's a good point.
Yeah, I think ultimately what it boils down to is if there is a transaction, this is information that is necessary to a seller. But if it's outside of a transaction, make sure you are contacting the association.
Okay, thank
But
you.
I just want to jump in one more second there and say, because this is a huge pet peeve of mine. It's why I wrote that condo blog that's at the back of at the top of your notes here, everyone. And also why we're doing this Zoom even prior to Surfside. This was on our agenda. You guys can't see it at my home office. I've got a whiteboard here with all the different ideas I have. And this a pet peeve of mine is that a lot of agents do not know the answers to these questions. They don't have the documents. So if you've got them and you've notified the condo association, your seller are good with you getting them out there or having them available for a potential buyer that's not under contract, why would you sit and hold that information back as long as your seller and the association are there? Because otherwise you are wasting your seller's time too. If this goes under contract to a buyer who would have never gone under contract or couldn't get it financed. So that's just throwing out a little bit of realistic, I think that's thunder out there, realistic piece of information there beyond the disclosure requirements. But Matt, definitely a great point on the disclosure.
So I got a couple more questions. Nikita, looks like you're asking concerning missing pages, it looks like, to buy rules. And so is there an organization where those would be originally filed, where you can get the missing pages? Yes, absolutely. A valid governing document, declaration, the bylaws, that or amendments to them, those are going to be recorded with the Recorder of Deeds office. So Cook County has a Recorder of Deeds. DuPage County has a Recorder of Deeds. Will County has a Recorder of Deeds. That's where you're going to get those original documents if the board doesn't have them. So I would first go to the board, property management. If that's the version that they have, then the Cook County Recorder of Deeds is going to have that information. Is there a good way to regularly manage inspection of the building to make sure appropriate maintenance is taking place? I'm in a 3-unit building where all the unit owners are also on the board. So you're self-managed, I would imagine, with 3 units. It doesn't make sense to likely engage the services of a property manager. I think it's really use your best judgment. I don't think there's a hard and fast rule in terms of looking at your home. There are some great resources that are seasonal in nature. So come winter, come fall, we're looking at gutters and we're making sure gutters and leaves are cleaned because ice damming is an issue. And, every October we're replacing carbon monoxide filters. I would say at the very least, you want to be looking at your building's health, physical health, at least on a yearly basis, if not more. There are some projects that just make sense to do seasonally. You might be clearing leaves out of the gutters every fall, if that's the case. And so that's the opportunity to kind of take a look around at the roof. But there is no hard and fast rule there. I think it's really just being reasonable, being proactive, and kind of keeping your eyes and ears open. These are great questions. Let's see.
Can you answer Angela's? Because I'm curious about that. And then also, I bet you Rob might be too.
So, can you prevent video or audio recordings in a meeting? I'm assuming like someone sitting on their cell phone and recording it. That I'm guessing that's probably the context, and not like it's an unauthorized video or recording. If it's an unauthorized and someone's on the sly recording, that's not proper. I mean, that's an invasion of privacy. As far as kind of rule, I think the best way to kind of approach that would be to adopt a rule for proper decorum and, you know, doing that. If someone is going to record a meeting, they need to notify everyone. They need, if they're recording people, that everyone needs to be notified and consent to that. So especially in a board setting context, or board meeting, I should say. If you're just recording someone and it's not in a board meeting, that's a different analysis, and you can't prevent that. Does that make sense? Okay, yeah, I got a thanks. Let's see, Nick, you got a question. Nick, what's your question?
So one more question for you really would be, oh, well, did you answer the one about if you can't, yeah, the one from the beginning of our Q&A session, if you as a buyer can't get a copy, so suppose the seller's like, oh yeah, we'll get you the documents, or the condo association's running super slow. I won't mention the name of the building, but there's one on the north side that the entire management team got COVID. And so my buyer could not get the condo docs they needed. The seller didn't have them. Well, you know, they'd lived there 10 years. My buyer wanted to delay or extend attorney review so that they could have time to review that. Is that a reasonable thing that we, you know, to me, I want my buyer to have the documents they need in order to make a decision. What are your thoughts on that?
I think if you don't have the information that you need to conduct a meaningful attorney review, then that is absolutely sound basis to request additional time. I'll be frank with you again, I don't handle real estate transactions, but just kind of knowing the law and knowing, you know, reasonableness, if someone's withholding that information, you have a basis to extend that. I would want to get everything solidified in writing, just good practice. Contact the other side, explain to them the situation, get it confirmed in writing, because you don't want a deal to not go, you know, or to go awry because attorney review expired and, you know, there wasn't any movement. But if they're withholding information that you've requested, I think that's sound basis for a reasonable extension until you provided that info.
Perfect. I just put Matt's contact information again in the chat box. I would strongly encourage you to join myself, Rob, and others that are kind of in the activism state of wanting to be better or better their condo association, protect their own investment, and get involved with your condo board. Doesn't necessarily mean you have to be on it, but check in and see what they're doing, sit in on a meeting. A lot of them, as Matt said, are now on Zoom. Just, you know, be aware on the way in and stay aware while you're there of what's going on. Matt, I really appreciate your time tonight. As you guys may be able to hear in the background, that storm is right outside my window. So I'm probably I don't want to get cut off here, but this will be recorded. Matt, take us out of here in terms of final words. We are so appreciative for your wisdom tonight.
I think, you know, ultimately, I think a lot of this, it's common sense. If there's a red flag, you know, do some investigation. You need to be an informed consumer when you're buying into these properties. There's a lot more to condo association life than what's on the surface, and knowledge is power. So whether you're a unit owner, a board member, or you're a prospective buyer, you have a right and an obligation to do your due diligence. And not doing due diligence is a huge umbrella for legal pitfall. So it just nurtures legal pitfalls and issues. So put in the work, be proactive early on to avoid the mess later.
Matt, thank you again for your time. Everyone, what a great resource for you if you are on a condo board, maybe looking for some new advice. I know we're going to be talking to Matt on behalf of my board. And then also, everyone, in the upcoming months, stay tuned to our social feeds. We are going to be talking about green, going green, sustainable energy. And then one of those big things is going to be doing that in a condo association. How does that look? So we've got some really great continuing things for you coming up from our consumer education series. Thank you all for being here tonight. This has been recorded. We will put that out there for all of you on YouTube.
Thanks, everyone. Take care.
Thank you.